Hey guys, this is John Watts. I always appreciate you leaving comments and questions, and that gives me a lot of ideas because I want to bring you videos that actually matter to you. So when you leave me comments, that gives me an idea of what you're interested in. So we've gotten some comments on a recent video where we have a situation where the original creditor is suing, and maybe they're suing in their name, but it's been sold to a debt buyer. And so I just thought, well, I'll knock out these comments in one video rather than splitting it up. So first, KSV says, funny how this is brought up because there's a company saying they're AT&T, but their letterhead is a collection company with no reference to AT&T on it. So, this would not be a lawsuit, but this would be a collection letter. So you have to read that very closely because they may be saying, hey, we represent AT&T or we're collecting on behalf of AT&T. Now, if they are saying that they are AT&T and they're not, well, then that's a lie. Okay, so I would just study that letter very carefully and definitely sit down with a lawyer. I mean, you don't have to do it in person. You can email it to a lawyer who's in your state that does the FDCPA, so files lawsuits under the Fair Debt Collection Practices Act, and say, hey, does this look like it's deceptive to you, that it's misleading to you? And that could very well be a claim. Or it may be that they're doing it right, they're just wording it in kind of an awkward way. So I would definitely check that out. And then we have AI2T-Man, and I think that's who originally posted the comment that sort of led to this. And says the issue is the original creditor won't say they sold it, but they don't say they haven't sold it either. They tell me to talk to Track America. I feel like the only time I get straight answers will be in discovery. And even then, the deck will be stacked against me if the original creditor, Track America, and the law firm, who's also a collection agency, are all on the same team. So, yeah, that is a frustrating situation. And what I would do, I think, is call the original creditor. And look, if they say on there, all calls may be recorded or monitored, then if you feel comfortable, you record the call. And just sort of nail them down. Like, no, I want you to tell me, have you sold the debt to Track America or do you still own it? It's a pretty simple question. You either own it or you sold it. Which one? Now, the person on the phone may say, I'm not talking to you. You have to talk to Track America and say, well, what's the phone number for Track America? And then call Track America. And they're not really set up for, consumer calls. But again, you could ask them. You could ask the collection lawyer. The collection lawyer is a debt collector. The collection lawyer is subject to the Fair Debt Collection Practices Act. And say, look, I want you to tell me the truth. Let's say it's Capital One. Does Capital One own this or have they sold the debt? It's a pretty simple question. It's either yes or no. Okay. And again, what I mentioned, I think, in this original video is check out your credit reports. And again, going with Capital One. Does Capital One still show up on your credit reports? Is it the same amount? Are they reporting every month? Because if an original creditor has an account that hasn't been sold, then they are to update that every month. So you should have February, may even have March. And if it's been sold, they'll say at the bottom under comments, transferred or sold to another lender. Now, they certainly can if they want to deceive you, do the credit reporting that way. But here's what happens as a practical matter. These big companies, the credit reporting's over here, the legal department's over here, and a lot of times they'll be sort of doing the opposite. Okay, so they're not necessarily unified on this. But then you can get discovery. And again, you just ask very simple, very straightforward, no wiggle room. On the date that you filed suit against me, did you own this debt or had you sold it? The day you signed these interrogatory responses, do you own it or have you sold it? What's your relationship with Track America? And so if I had to guess, I would say the odds are that they have not sold it. And Track America is doing what I mentioned in the original video. They're just sort of like the middleman to go find, we're going to use this law firm in, I don't know where you are, but let's just say North Carolina. We'll make sure we get the right collection law firm in North Carolina. That's probably what it is, but it's worth exploring because, I mean, I'm dealing with this right now where I have the suits in the name of the original creditor. They did not own it, okay? And there's really a debt collector behind it. So it does happen. It's not common, but it does happen. So, and let me know what you find out on that. And then Gene says, let me expand this comment here. Very interesting. Latest book papers I received from the lawyer for the plaintiff. There's an affidavit by the lawyer where he refers to the debt buyer, but speaks as if he's talking about the original creditor. And then he refers to the plaintiff as a debt buyer. So which plaintiff are you talking about? Who's suing me? It's LVMV, but now it sounds like they're also referring to the original creditor. So yeah, sometimes people are, how can I say this, accidentally sloppy, and sometimes they're intentionally ambiguous. So sometimes you'll see in the lawsuit by, let's just take LVMV, it'll say, plaintiff had an account with, or let me rephrase that, it'll say something like, plaintiff issued a credit card to defendant. Well, is that true? Did LVMV issue me a credit card? Nope, that's a lie. Okay. You know, plaintiff sent monthly statements to defendant. That's not true. That's a lie. Okay. And then other times they're sort of vague and ambiguous. So it's definitely something to press them on. And then Gene says, I have another small or maybe big question. The person who signed as a notary public for the affidavit did not print their name after under the signature, which is completely illegible. And so is that legal? So I've seen that also where, you know, it's like a line, you know, it's just like sort of maybe the beginning of a J and then just the like, who is this? And they don't print their name and their name is not listed in the affidavit. Like when we do an affidavit, we would say, comes now, you know, Joe Smith, after being duly sworn, states as follows. And then we'd print his name and he would sign. Okay. But these people will have, comes now the undersigned and he, parentheses, or I guess it'd be like an S and then parentheses HE. So it's kind of like she, he, you know, they don't even specify, is this a man? Is this a woman? You know, sometimes they don't even name the original creditor. They'll just say, we bought it from the original creditor or an assigned. It's like, what in the world? Okay. So I don't know that it is illegal to not spell out the name of the notary public, but it's something I would raise. You know, when you see all this sloppiness and they're up there telling the judge, but judge, you know, this is absolutely the truth. I mean, you can trust us. We got this. It's so accurate. And then you start pointing out, well, what about this? And they go, oh, well, that was just a little mistake. What about that? Well, that was just a little typo. Well, what about this? Well, you know, yeah, maybe I should have worded that. Well, what about that? And that starts to build up to the judge where the judge says, I don't think I trust you. So I had a case one time and it was, we're at trial and it was Midland Funding. And the person doing the affidavit was with Midland Credit. And they said, you know, Midland Credit bought this debt. And I pointed out to the judge, well, okay, maybe Midland Credit bought it, but Midland Funding sued me. That's not the same thing. And they go, oh, well, you know, we're sister companies. I mean, that was just typo. They should have put Midland Funding in here and it doesn't make any difference. And we're all owned by the same people and blah, blah, blah. And I'm like, well, they claim to be separate corporations. Now, I'll admit that they do act as the same. Okay, so, you know, I'll have somebody sued by Midland Credit and Midland Funding will do the reporting on, say, Equifax and Midland Credit on the other two. So they do act together. But if they're going to act together when they sue us, they got to provide the proof of that. So, you know, I pointed that out. And again, the lawyer's like, well, it's just typos, no big deal. And judge's like, come on, if you can't even get the name right, why would I trust you on anything else? So that's the power of pointing out these errors, okay, including like you've done here, Gene, with the affidavit. So hope that this has been helpful and you guys keep comments coming, and I'll also do sort of, you know, original videos, but I really like to answer questions that you guys have, and I just haven't had an opportunity to do a YouTube live, just sort of crazy trial schedule. I think I have like 8 cases set this week, and probably most will get settled. But it's just a little crazy right now in a good way. We're having a lot of trials, filing a lot of lawsuits, so things are good, but that does limit my time. So I just try to grab these comments when I can. And you guys take care, and you have a great week. Bye-bye.